So we will start by looking at this decision tree on what constitutes an intangible according to the Chapter 6 of the OECD guidelines. And depending on the answer to questions such as, is the asset a physical or financial asset, or is the intangible protectable or protectable under law, we may land or not in the definition of an intangible according to Chapter 6. So these are pretty straightforward questions, and they are laid out in the first part of the Chapter 6 of the guidelines, except that in reality it can be quite challenging to determine what actually constitutes an intangible. Because as we have seen in the previous session, there are different angles of looking at IP. And there are different understandings of what an intangible is, and it varies significantly from one profession to the other. So there is an IP lawyer's understanding of what constitutes an intangible, and accountants, and tax professionals, and even in the tax world, the interpretation varies from one jurisdiction to the other. And this means that you may end up with multiple definitions on what constitutes intangibles. Okay. So an illustration of this complexity is a dispute in the Coca-Cola case, where the issue was whether a taxpayer's foreign licensees paid an arm's length royalty rate for the use of product and marketing intangibles owned by the US parent. And how residual profits should be allocated was the crucial factor here. So, Raymund, do you want to take it from here?
Yeah, I'm fine on that one. Thank you very much, Anna. I think what Anna was saying is that, you know, a lot of authorities will look to use or claim to use similar definitions of what is an intangible, but in actual fact, what we can see, and this is one of the examples, and we will show probably two more if we have time enough, that authorities are actually looking at the facts and creating an interpretation of the facts and try to park them then into what we all consider to be definitions that we all agree to or seem to agree to. In the Coca-Cola case, the two companies on the, if you look at the left-hand side and you look at how Coca-Cola goes from syrup to production of syrup to sale of syrup, going to bottlers and then going to the market through local distributors, be it retail or local sales to individuals. What you should be aware of in the Coca-Cola situation is that the company itself that has all the rights to the famous syrup, which is secret, the company in Atlanta in the US, they have at the global level subsidiaries that are to a large extent units that produce the syrup, the concentrate, and sell the concentrate to the bottlers. The bottlers are to a large extent independent from the Coca-Cola company as we know it. They all carry similar names or go marketing under the name Coca-Cola, but you have, for instance, the Coca-Cola European partners. They take a piece of the Western European market for bottling, but they're completely independent and stock quoted. And so we have also others in terms of bottling companies that are out there. Sometimes the Coca-Cola company itself has shares, or be it minority or owner of a local bottler. What we're talking about in the case at hand is essentially looking at the subsidiaries of the Coca-Cola company in the US. They basically produce, but they also pay money for the local marketing activities they carry out under the guidance of the Coca-Cola company. So there is a sort of a marketing approach. We can call it the brand book, if you will, that comes from the US, but the application of that book is then rolled out at local levels. The local companies are paying for these kind of expenses. And what now was the question, maybe we can go to the next slide. the Coca-Cola organization has had a ruling with the IRS, which already stems back to 1987, when they had an audit settlement on how to allocate the profit between the headquarter and basically the licensees, being the local subsidiaries, the production companies. Now, on that basis of the settlement, the Coca-Cola regional company was getting sort of effectively a 10%, call it for the routine services, be it manufacturing. They got about 10% of the market, of the margin. And then the rest of the residual was split 50-50 between the US and the local hub. This continued even after the period 95, after 95 was effectively ending. They continued to use the same methodology and applied that through the years, as you can see here, from 96 to 2006. And the IRS, without anything in writing, accepted that approach. However, and maybe we can go to the next slide, the IRS was actually saying, we no longer want this. We feel that essentially all marketing intangibles are owned in the US, and the US should be fully compensated for that. And the local subs do not have anything that they could claim for marketing intangibles. So in other words, the residual profit was, in the eyes of the IRS, really in the US and should be fully rewarded as such. And effectively, they also said that the local companies should actually get a routine based on a 5% effective markup on the production and the selling cost. So that ends up with, as you can see here, production cost plus 2.5 and selling cost plus 2.5, effectively getting a 5% element of the profit that is to be divided among the parties in the game. So what you see here is essentially the IRS saying, we do not recognize that at the level of the hubs, of the regional hubs, i.e. the subsidiaries, that despite the fact that they execute under the brand book, that they are working on the total, how shall I say that, on the total marketing program, also paying cost in that sense, they don't have anything in terms of economic rights to the marketing intangible that is effectively created by the group as a whole. There have been a number of writers, and this case is still going on. It's not yet, to our knowledge, completely settled, but there is still a discussion going on where they make a comparison, for instance, to a franchisee organization like, if you will, McDonald's and others, where McDonald's is also asking for a certain amount of royalty, if you will, but they will also force in their contract the independent franchisor to participate in the local marketing expenses. And what we find there, for instance, is that the local independent franchisors thus are running a risk on these advertising costs, plus the royalty they pay to McDonald's in the US, that if they don't sell enough, they really incur a risk. And the analogy here is made that the same could happen with the Coca-Cola regional hub, and thus should also get compensated for that risk, meaning there is some kind of sharing in the residual profit needed. So this approach that the IRS is taking here, that you see on this slide, where it only allows the 5% routine and assuming no risk, there's a big debate going on whether this is the right approach. I'm not sure whether, Louan, you have a feel for this. Do you have a point that you want to share on this? Is this making sense from your perspective? You're on mute, Louan. Yep. No, you're on mute again.
Okay, yes.
Yep.
It's okay.
Yes.
I see your point. This the point of the IRS is that the Atlanta community is just the brain trust of the success of Coca-Cola, as has been demonstrated over the years, and it is hardly possible to have some counter evidence, and then the reference to the franchisee model as evidence as put into place by McDonald's and others and Burger King and whatever. Yeah, that could be an argument in their advantage. But yeah, this time it is after BEPS and after the holistic approach, value creation has come into place and has been accorded in the 2070 guidelines. I wonder, but that's not what happened in the case itself, because it was before that time started. But I wonder whether this could be upheld also in this time. So I think that then the value creation analysis, what technique, qualitative or quantitative, you will apply, might be tantamount to creating a split in marketing intangible at the one time and production intangible at the other hand, and then the position of the IRS will not stay in existence the way it might be in this case.
Mm-hmm.
We're not sure of that.
Yeah. Yeah, if we go to the next slide, maybe we can elaborate a little bit further on this one, because in this particular case, the IRS took a similar approach with the DHL case, where there was a trademark agreement in place which was sort of valuing the trademark at a 20 million amount, whereas, you know, when this went to court, basically the IRS was looking at a value that they wanted to assign as much as possible to the DHL US headquarters. They even came to a different number than this 20 million. As you can imagine, they started off with 150 million number. Then they said about 2/3 of that is brand, of which, you know, the biggest chunk will be allocable to the US. So they wanted to bring as much value again to the US, where not accepting sort of the marketing intangible of what was happening in Hong Kong, where their subsidiary was actually, again, similar situation as with maybe the Coca-Cola situation, where the local company was incurring quite heavy cost of advertising and marketing, again, under the same type of, you know, brand book requirements coming from the headquarters, but still incurring quite a lot of cost, and arguably creating a marketing intangible. In this case, it went to court, it went to the trial court, and it was also going through the appeals court. In the appeals court, which is the final conclusion on this case, effectively, the appeals court said there is economic ownership which is shared between the Hong Kong subsidiary and the parent in the US. And they actually came to a conclusion of a 50-50. So the IRS position was a little bit similar to what they're stating at Coca-Cola, where there is no marketing intangible at the local level. But in this particular case, the DHL case, the court decided to actually award you know, the subsidiary an entitlement to the economic value of the brand DHL as such. So we need to see what then development will be at the level of the Coca-Cola situation, whether that will find its way into court or not. But at this point in time, we can see that you know, there's still a debate going on about how to split you know, the benefits, and whether yes or no the local company will have the right to a piece of the residual profit. Louan, a question in this context, and,
Yeah.
and discussed this a couple of times. if you again take the comparison between companies that are related versus companies that are unrelated, in a situation that you have a related party, how do you judge the concept of an implicit guarantee? Because if I take the example again of Coca-Cola, I cannot imagine that if indeed a local company incurs the risk of a loss, in other words, you know, if a syrup producer, because of its high cost on advertising, its manufacturing of the syrup, but not selling enough syrup to compensate for all its expenses, but still has to pay a lot of money over to the US parent, it could end up in a loss situation. If that loss situation lingers on and effectively threats this company to go bankrupt, I can hardly imagine that the Coca-Cola Atlanta company will allow this company to go bankrupt. Is that not, if we assume this to be right, is that not an argument that would work in favor of the IRS to say there is no risk at the level of the sub? Why would we give them an economic right to residual profit? Because they do not have the risk. The parent will step in, they will make a loan, they will put cash into the company, and they will have, in one or the other way, ensure that this company will not go bankrupt. This is obviously different in a McDonald's situation where McDonald's might let this company go bankrupt. How do you see that? Is that an argument in favor of the IRS if you look at the Coca-Cola case?
Yes or no? Yes and no. I think it might be an argument in favor of the IRS because it is a related situation between associated companies, and parent companies in a group are more inclined, and they are also obliged because it's in their own interest to sustain their group companies if they are threatening to be in a bankruptcy situation. I don't think that is a non-arm's length situation, position. I think that is really arm's length because it's in the interest of the group position. On the other hand, in a non-associated situation, the head or a principal company could also be inclined to sustain local marketing companies if they try to become in a bankrupt, go bankrupt, but not that far and that often as a group company will do it. So I think there is a gradual difference between the two. So it might be in the argument the IRS could take as a point, as a line of point in their advantage, but it's not really necessary because I had the same experience that when you work with local distributors, local sales companies, and you have a good market position, yeah, then you want to help if based on whatever circumstances, a local marketing entity not associated is threatened to go bankrupt. You are often, not always, but often inclined to give their a subsidy or to lower the pricing in order to uphold their position in your own interest. And that doesn't have to be only an associated position. But in a group situation, yes, the implicit guarantee, or it shouldn't be a guarantee, but an implicit situation could be at stake. So it could exceed a sort of bright line, but not always. It's always so that, and going bankrupt is an extreme situation, and the risk is not similar. Risk is not equal to going bankrupt of not bankrupt. Risk is inventory risk, is capacity risk, is creditors risk, and whatever. And there are a lot of risk which can happen and which can touch the position of a local company, a local marketing company, without they are being to go to land into a bankruptcy situation. So there are a lot of levels in which a headquarter company can be inclined and feel obliged to sustain a local company. So it could also be an argument not in favor of the headquarter company as well.
Yeah, the fact of the matter is that we know, for instance, from the Coca-Cola organization with the pandemic situation that we're in, there have been a lot of their distributors, their local distributors, which are usually, how shall I say that, doesn't have to be a big company. They can sometimes be a mom and pop shop that is in the local area trying to sell the Coca-Cola products.
Yeah.
But there are sometimes also bigger units where these companies lock down, restaurants are closed, bars are closed, they don't sell enough. Those companies seem to be going into a situation where they cannot sustain themselves anymore. They're independent from the Coca-Cola organization, but that the Coca-Cola organization is still considering to support these independent distributors. And the argument being relatively straightforward. The Coca-Cola organization has over time obviously built up a network of distributors on the global scale to distribute their products. That has been a long lasting effort over many years, has been an investment in their own distribution channel, if you will, from the production of the syrup all the way down to the consumer. And if you would let this independent distributor go bankrupt because of the pandemic, and you would have to come back and rebuild this organization over time, it's going to take a lot of money again, a lot of effort, and you should hope that you get back into that country, into that region, reaching again those consumers that you were able to reach. That it probably makes sense to find a way to support these independent local distributors, which are not your related party. So that argument almost seems to indicate that they would definitely do it for the subs, but they're even doing it for their non-related companies, not to lose out on when the market is coming back, so that they have an immediate pickup also on their side on their products. So there is a bit of selfish interest as well to keep and to manage these risks from the center, which again, I'm just throwing it out. I don't say this is the right answer, but it almost seems that the real one taking the risk, and also in unrelated parties, relationships, the head office seems to be willing to take on risk to protect its own business on a global scale, which again could be arguably an argument for in favor of the IRS in the situation of the Coca-Cola case, to get more of the residual effectively back to where the risk is managed, and not recognizing at all any marketing intangible at the level of the sub is probably a step too far, but that a big chunk of that value should be recognized in this particular case, if you go back to Coca-Cola again, and also in the situation here, that there is some kind of allocation, seems to be the direction that also the DHL case was going and has gone. Maybe that's also what will happen on the Coca-Cola case. If we take a step further, there is one famous case. It's already an older one, but it is underpinning, in a way, what was just stated and discussed. If you go to the next slide, Anna, maybe some of you, next slide, please. Sorry. If some of you might remember the GSK case, which was quite a novel situation at the time, especially for Europe, in the transfer pricing arena. This dates back to 2006, if I'm not mistaken. But in essence, what situation, it's pretty straightforward, if you will. GSK was a UK, and still is a UK headquartered pharmaceutical company. They produced, or they ran a lot of R&D at the level of the UK. They developed all the patents, they registered all the patents, they produced the marketing platform, read the brand book in the way how to promote the relevant product. In this particular case, Zantac was one of the big products out of a pool of products. There were about 6-7 products involved, but Zantac made up 70% of the business, or even more. It was 77, I believe. And what was actually the arrangement before the IRS stepped in? The arrangement was that the UK would give a distribution license to GSK subsidiary in the US, and they would also sell the active ingredient, the underlying medication and formula, to the US, and the US would be doing effectively opening up the market in the US by putting the sales team in place, by putting in place effectively the platform created by the UK to apply that also in the US. They used effectively a resale minus methodology to reward the US for the two services. By selling the active ingredient, they effectively allowed sort of a 55% margin in gross margin in the US. That was sort of the ingoing position. So here you have, to a certain extent, some kind of recognition for the efforts that the US firm is doing. But what did the IRS say? If you go to the next page, the IRS was actually doing again the same thing, but now in the reverse. They basically said, no, there is much more marketing intangible that you can recognize in the US than what you claim. So here the IRS was using, again, an argument of marketing intangible, but now in favor of a subsidiary of the group and not the headquarter, which seems to be a little bit inconsistent if you remember the Coca Cola situation and the situation of DHL. It goes back also a little bit from the interpretation of the facts. If you go back to what Anna was saying and what Steve was saying in the earlier plenary discussion, there are different lenses that you can use, or maybe you have to use, in looking at intangibles and recognizing what kind of intangibles are we talking about. The IRS in this particular case was one of the first times they came up with the concept of the marketing intangible, actually, that the US was doing more and delivering more value in particular by allowing this product to the US market and bringing it to the US market and being very successful about bringing it to the US market. This discussion was also, a long and winding one, where essentially the IRS came to a settlement. This never reached the courts. The companies were discussing this for many, many years, and the ultimate settlement resulted effectively in a reduction of the resale minus. So in other words, the cost charged by the UK for the ingredient was lowered, thus recognizing that something was happening at the level of the US, i.e. that yes, GSK US was building a marketing intangible for the UK company in the US, for which it needed to be rewarded. And the IRS went a couple of steps further by saying, look, we want the production cost to be recovered with a markup, and that's sort of on the contract manufacturing piece. And for the other side, we say, when you bring the product and give us the license for distribution, we want more of the residual value. And that's resulting effectively into something close to a 60% for the US effectively, and 40% for the UK in this particular case, whereas before it was virtually the reverse. They had, in the setup of this arrangement, effectively the UK making about 60% of the total profit, whereas the US was getting about 40%. I'm just rounding numbers for people that want to get the right numbers. It's a little bit more specific, but that's roughly what it boils down to. But here we see already an early case where also the IRS in a settlement basically said there is a marketing intangible at the subsidiary level. So again, I'm coming to the point what the Coca-Cola case will look like as an outcome is obviously in the stars. And if we had a crystal ball, we all would be millionaires, if not more. So I'm very interested and very curious to see what the IRS will ultimately settle on with the Coca-Cola organization, bearing in mind the way they started the whole game of claiming a marketing intangible, which started more or less with this Glaxo case, which we saw on the DHL case, and which we see again coming back with that Coca. I'm just wondering, Louan, how do you see this? Do you see that the IRS, and maybe in that sense, maybe any tax authority on a global scale, they're obviously arguing based on the facts they get at hand, and then it's a matter of their interpretation of whether it falls within a marketing intangible, whether they recognize it or not. How do you see that on your side?
Yeah, I think that is really the case. It should be the case, again, based on maybe VCA-like approaches, but other approaches are possible, so discounted cash flow and whatever. But the marketing intangible, it already existed way long before the marketing and the trade intangibles are set against each other in old guidelines as well. So it is nothing new, but this one is new. The reversal of positions in that the UK company or companies are only contracting services, and that the leading position is taken over by the US company, because they created the intangible. That's a huge intangible. Yeah, that's a trend. I think that's a trend that is going forward, not only in this case, but and in Coca-Cola case, but in many cases coming to the fore in times to future times. So I fully think that this is creating a trend which will be followed in jurisprudence, not only in the US but also elsewhere.
Louan, there was a question that came, and honestly, I don't know the answer to the question. Martin was asking, do we know of these cases what the corresponding adjustment was at the level of, the counter side of the adjustments? Do you know in the case of DHL and also here Glaxo, do you recall any corresponding adjustment at the level of the UK and on the other side, the Hong Kong US relationship? Do you remember? I know for sure that we didn't look at it, particularly because we focused on the recognition of the intangible, and that was the element we pulled out of the case. Yeah. So the focus was not on looking at the net effect and whether there was double taxation or not, but it is a fair question, but you also don't have that readily available.
But the point is that this case was settled, so there was no clear position from the court, and that. So I wonder whether if it is settled, then a corresponding adjustment could be asked and could be granted. But I think that the other jurisdiction is not obliged to do that based on the Model Tax Treaty, Article 9.2, the OECD Tax Treaty, and also the US or the UN Tax Treaty. So I wonder whether this happened. I'm not sure of it, but based on the fact that it has been settled, so we never know what the US court would have pronounced as a verdict. I wonder whether there has been a corresponding adjustment. So I think the settlement, 3.1 billion, I think,
Yeah.
from the top of my heart, that's the end game. That's the group, the Glaxo group is is satisfied to a certain extent with that they have to pay that amount of taxes. But we can have a look, of course. Maybe.
But that would mean in that situation that if it is a settlement, then it's just it didn't go through competent authority discussions.
That's what I mean. Yeah.
Suggest that you may not get it automatically, but the question is whether you could ask, which is then a new procedure in its own right, right?
Yeah, you could ask to do that. Yeah, but I think that there is not a treaty-wise, there is not an obligation. That's what I want to say. But of course, it is a possibility to do that. But
yeah, you may recall from the discussions we had yesterday.
Yeah.
There was a statement made by Steve when we talked about aggressive authorities or authorities that were not necessarily, following, I don't know, the quality requirements that we may all want from them. And the example came up again with Italy, where if you settle in Italy, you also effectively abstain from any corresponding adjustment. Because that's in the settlement with the Italian tax authorities, you effectively confirm that you will not bring this to arbitrage.
Yeah.
Sort of getting this corresponding adjustment, they simply don't want to get involved in it. It seems, but that suggests that you have, economic double taxation on your hands from that side.
Yeah. Yeah, so that's the point. There's always the point. Also based on application of the tax treaties and the tax convention, that no country is really obliged to give in automatically because it has its own judgment about the justifying arguments for increasing the increase in the tax amount at the other side. So there's always the possibility, and it has to be done in an MAP situation, I think, or other in Europe under the so-called European Arbitration Convention, that it is not a mathematical certainty. You have always to go into in treaty negotiations, and that's also if there is not a settlement, and never sure that you can end up into a double taxation, and then it's depending on your negotiating expertise, whether you are ending up into a total amount built up from the tax increase or the tax amount of two jurisdictions, which is even then satisfying for the company in that order that they don't that they know for sure that's what we have to pay. We can now inform our shareholders, and that's it.
Yeah. Okay. Can you go to the next slide, maybe, Anna? Actually, when we started to look at this, we were wondering what is actually the message that we're bringing to our audience, to you in particular. And if you look at it, we started off already saying, and it's a repeat of what also Steve said in the introduction plenary element, is we may have definitions of what is IP, how we then judge its value, how we subsequently deal with allocation of the value that such a intangible brings. It's all over the place. And if you look here, where we look at some of these US cases that we shared with you, you see that just at the face of it, the US IRS takes 180-degree different positions. So on the one hand, they say there is no marketing intangible, and on the other hand, they say there is a marketing intangible. It is not a big surprise that we see, obviously, them creating the argument that is obviously beneficial to the IRS itself. I don't think that's a surprise. And they may, in the interpretation of facts, may even have a point if, for instance, this argument of the implicit guarantee discussion that I triggered, if that holds up, and if you take into account with Coca-Cola trying to protect its independent local distributors, then you have another argument on this implicit type of guarantee discussion, the whole risk and risk management aspect, which is something that is relevant for BEPS. If you think about DEMPI, then you almost you almost will have sort of a situation where you have to say, is it not all done in the US in some of these examples that we dealt with? So maybe the IRS does have a point. And how does that then trigger the discussion from the perspective of other taxing authorities looking at intangibles? How does it, what does it require actually from everybody in order to justify and anchor, if you will, an intangible that we believe belongs in a given country? How do we anchor it? Do we need to look at functional profiles of these units? Do we need to go through this DEMPI analysis? Do we have to look at people and what they do and what they actually manage? Or is it simply saying, well, we expense marketing expenses in a country, we take them as a deduction, so we have the right to also claim the revenues or a piece of the residual profit to our local entity? How far do we need to go? And I think the complexity here will translate in what is really your commercial model. How does your business model look like? How does your governance around the management of your business and your intangibles in particular, how is that dealt with? I think these are elements which, you know, we're not giving you any straight answers, because it appears that the facts underlying need to be interpreted, and that's where you have a position to, maybe the word design is the wrong word, but where you at least have the opportunity with your business to say, I want to anchor it in a country. These are the requirements in terms of business decision powers, execution powers that need to be in the given country where you want it or where you deem it to be based on your business model. The only recommendation is to create the audit trail to support those kind of positions. And DEMPI seems still to be an aspect that with the OECD seems to resonate. And maybe even from its functional activity seems to resonate also for the US. Although maybe they're not admitting it. I'm not sure, Louan, am I going too far now?
No, not too far. I think this is the ongoing trend which you describe. This is really the trend which is not turning around, but this is in a sort of linear movement is coming to a sort of suboptimal position over time. So I'm fully subscribing. It is also the 2070 guidelines, or the value creation, and then combined, and let's not forget about that, with people functions. That is even more important. And if people can be the most valuable type of capital, or of capital in the sense of what is the IP of a company. So it is very important that there is an R&D group somewhere in, for instance, the UK of Ireland. So as Santac is a good stomach prescription. But then someone has to make it true for the people at large, and so the marketing is getting more and more importance, and marketing value and marketing intangible is just one of the straightforward notions in transfer pricing, which anyone knows that we have to get our hands around it in order to value it and to see whether it is important or not. So you cannot turn around it and claw back it to an earlier period. It's going forward and is getting more and more important.
Mm-hmm. In terms of, it's funny because if you look at maybe I'm working on a case here in Switzerland, also on valuation. In the situation we were talking with all these companies that we brought to the forefront today, there we were looking at the intangible itself and trying to put a number on the intangible per se, almost like transactional. In the situation here in Switzerland, we have had a change in this legislation, which was sort of forced upon Switzerland by the EU and through the through the trade organizations. As a result, there is a change in systematics here of principal companies that we know very well here in Switzerland. And these companies have now been, as a sort of a grandfathering, been allowed to do a tax-free step-up of their intangible, as they refer to it. So here we have, again, a step-up of the intangible. And if you look at the way the model is working, how do you do that? And we're now in a situation that we're basically valuing a company in terms of its operations. So the intangible is, to a certain extent, the return on the brand, the return on maybe the know-how and the technical knowledge that we have, but it also includes, to a large extent, the goodwill of the business, because the intangible seems to be bringing the value, which is just business revenue. So we're in a discussion around value, which is more comprehensive than just looking at the intangible asset itself. It is also taking into account the goodwill element. And that's, I think we're now being pulled back into the main room